Welcome to the Florida Bar Podcast, where we highlight the latest trends in law office and law practice management to help you run your law firm. Brought to you by the Florida Bar's Practice Resource Institute. You're listening to Legal Talk Network.
Hello, and welcome to the Florida Bar Podcast, brought to you by the Practice Resource Institute on Legal Talk Network. This is Karla Eckhardt, recording from the 2018 Annual Florida Bar Convention in Orlando, Florida. Thank you for joining us today. Joining me today, I have Peggy Hoyt and Alex Douglas, and we're going to talk about elder law. But before we do that, why don't you guys tell us a little bit about yourselves?
Thank you very much, Karla. This is Peggy, and I have a lot to say, I guess. We've been talking all day, but I am the incoming chair of the Animal Law section of the Florida Bar. I am a member of the Executive Council of the Solo Small Firm section of the Florida Bar, former past chair, and I've been practicing in the area of wills, trusts, and estates and elder law since I graduated from Stetson in 1994.
You've got experience. That's good. How about you, Alex?
I went to Washington University undergraduate, Florida State for law school.
Go Noles. Okay.
Absolutely. Been practicing, I think, 28 years now. And I'm also active in the Florida Bar Reptile Committee on the probate trust litigation subcommittee, as well as probate procedure.
Nice. So I like to hear that you guys are very involved with the bar, so that's great. It's also very appropriate that we are going to be talking about elder law today because for our listeners who don't know, tomorrow, the 15th, is going to be World Elder Abuse Awareness Day. So it's a perfect segue into today's topic. So let's get started.
That is a perfect segue. Yeah. And I think what I'll mention to start out with is that elder abuse doesn't necessarily mean that we're holding our seniors down and hitting them. It can take all kinds of forms, right. Including exploitation, financial, physical, of course, spiritual, mental, emotional. Exploitation and abuse come in all forms.
Right. We know it's been a topic of interest in Florida in particular lately. So what's any new legislation, any cases that we've seen that have really sort of moved elder law into the forefront of people's minds?
I think what's happening a lot on the elder law forefront, I don't know that there's any specific new legislation with regard to elder abuse. Alex may be able to comment on that. I think there is a greater awareness, though, and I would encourage anybody who might be aware of elder abuse to call the Elder Abuse Hotline. And would you happen to know that hotline? Is it something we can add to the podcast later?
We can get that number.
I think it's 1-800-ELDER-ABUSE.
Beautiful.
It could very well be.
We'll fix that if that's not it.
And there is, as I understand, pending legislation that will add some injunctive relief under the elder abuse statute. And a lot of, Peggy talked about the fact that elder abuse doesn't have to be just financial doesn't have to be just hurting someone physically. Oftentimes it is financial, though. And from my perspective as a fiduciary litigator, you see a lot of family members who are abusing their parents or their loved ones by financially taking advantage of them. And obviously when that happens, there's a lot of ways you can go about to remedy that, both under the elder abuse statute as well as the guardianship statute, and just common law actions for breach of fiduciary duty. It is a situation that is growing, unfortunately, as our elders age, and especially here in Florida. With all the retirees that we have, right. We are getting an explosion of cases, unfortunately, with regard to persons who have abused a power of attorney. A lot of elders don't understand how important and powerful a durable power of attorney is, and how very important it is if you are signing a power of attorney to make sure you carefully select who your attorney in fact will be. That person will be able to do everything that you can do, including taking money out of your bank account. And unfortunately, a lot of folks have given their power of attorney to the wrong family member or to the wrong friend. And when that happens, you have to intervene either through a guardianship proceeding, which both Peggy and I handle. I handle the ones that are contested, or you can pursue under the power of attorney statute certain remedies under that statute. It allows you to collect damages, attorney's fees, and the such. But the important thing is to report the elder abuse, and if you are able to take legal action very quickly. The longer you let situations kind of work out, as some people think they will, the more chance that the person who's abusing the elder will be able to dissipate their assets. And that's really where sometimes you may have a legal remedy, but practically the money's gone.
Right.
That's where the saying, you can't get blood from a stone, comes from.
Right.
So once the money's gone, it can be devastating to other family members that may be reliant on that money. I'm thinking of a case that Alex and I are involved in where the money was dissipated during the mother's lifetime, and at her death, the remainder was intended for an adult disabled child.
That is just terrible. So what can people do? Because this is an area of law that everyone is going to encounter at some point in their life. It's not like, not everyone's going to encounter criminal law in their lives.
Right.
Not everyone's going to commit a crime. But elder law is relevant to everyone at all ages.
It absolutely is. And Karla, it's a great question. And let me tell you, from a litigation perspective, the best thing you can do is go see an elder law lawyer and do your planning. Because if you plan correctly with your estate planning documents, your power of attorney, your living will, your pre-need guardian selection, you can certainly help the court, if it has to go to a judicial proceeding, help determine what your real desires are. And so many people, for instance, family members find themselves having to go to court to establish a guardianship for a parent, because that parent did not take the time and did not see in advance far enough that they may become incapacitated. And when you are incapacitated, it's too late.
Right.
You don't have capacity to sign legal documents. But if they had gone to see an estate planner, attorney, elder law attorney, and done basic estate planning, including a power of attorney and a pre-need guardian and the living will, which of course, tells your care provider what your wishes are if you're in a medical situation. All those things are so critically important to helping protect yourself and your finances. And if they're not done, then that's where people have to go to the unnecessary expense of filing for a guardianship. A guardianship is a very expensive proceeding that in most cases can be 100% avoidable if you just go do your estate planning.
Well, and we like to say that a guardianship is the worst kind of lawsuit because it's one that your family files against you. You get to pay for it, and ultimately you lose. And in fact, the whole family may lose because relationships get destroyed sometimes in the process. And I think one of the things that maybe elders are not aware of is when they sign a power of attorney, that power of attorney is effective the day it's signed. There doesn't have to be some disability event waiting out there in the future. And so really important, as Alex said earlier, make sure that you choose your people carefully and make sure that you keep that plan updated, because the people may change over time in terms of who you trust and who's available and your best interest overall.
Right. And what can someone, so we just talked about planning ahead of time, what can someone who's already, an elder person who's already in a bad situation do? What recourse do they have?
So if a person's already incapacitated, and this happens many times because family members tend to just kind of watch this person decline over time, thinking that they're going to get better or the circumstances are going to change. If that decline has happened and the person is now incapacitated and they have no planning, our only option is guardianship.
Okay.
And a guardianship, of course, is where you have to first determine whether the person's incapacitated. There's a 3-person medical panel that's appointed by the court. It's usually a doctor or a social worker, a psychiatrist, or a nurse. that examines the person, actually goes to their house and interviews them and examines them and does a report to the court. And if you have 2 out of 3 reports that come back that they're incapacitated, then the court can find that the person does have incapacity. The court then has to determine in what areas they're incapacitated. Are they fully incapacitated? If so, that's called a plenary guardianship. If they're only partially incapacitated, then the court has to specify, can they enter into contracts? Can they handle their finances? Those specific items that they're unable to do, that is delegated to a guardian. So the next stage is if the person is incapacitated, the court will appoint a guardian. Oftentimes, that's where the real fight is within families that are not getting along. It's brother who wants to be guardian over sister, or other family members, and those kind of cases can get very, very contentious. And sadly, oftentimes it's not so much over who can better care for mom or dad, but over who is going to control mom and dad's money. And a lot of times, after testimony is heard, the court can see through what is really going on. And, not in every case is that a prevalent theme, but in many cases, often the parties are really trying to gain control over finances. And that also goes to another issue about having a revocable trust. Because in a guardianship, the guardianship court only has jurisdiction over assets that are in the ward's name, so in the incapacitated person's name. If you have assets or in a trust with a trustee, those assets are not part of the guardianship. So that, again, is as Peggy can, I'm sure, state, having estate planning in place, including with a trust, is another way you can ensure that if you become incapacitated, you can have a successor trustee step in and manage your money and not have to be so dependent upon a court having to appoint a guardian to do that.
That's a very good point, Alex, because I think traditionally people have thought more about revocable living trusts in terms of avoid probate, save taxes.
Right.
Well, now that we have an estate tax exemption that's $11,200,000 times 2 if we're married, the taxes issue is not as important. People still think that avoiding probate somehow means avoiding lawyers. And they don't understand that it doesn't mean that we get to avoid the process. So I think the real benefit in having a revocable living trust is the fact that it does provide for a definition of incapacity. Who's going to decide that you're mentally disabled? And what I like about a trust is that first determination can be my own. I can decide that I'm not capable of managing my own financial affairs, and I can resign as trustee in favor of my personally selected successor trustees. If I'm not capable of making that decision independently, I can appoint one or more persons that I trust. I like to call it a disability panel that can be empowered to make a determination of disability when I don't necessarily agree with them because I've now lost my capacity to make that determination. Once my panel meets, they make a disability determination. The effect is to empower my successor trustee, and then that trustee must look to the instructions in the trust about my future care. So I can say, take care of me, take care of Karla, take care of my husband, take care of my next door neighbor. Oh, and definitely take care of my pets. That's another place that we can be very specific about how we want those that are closest to us to be cared for in the event of our incapacity. And the pet issue, I didn't mean to get off on a tangent, but the pet issue is actually one that guardianships don't deal well with.
Right.
Because in Florida, we still view our pets as personal property. There's no specific statute within the guardianship statutes that addresses what happens to pets or how they should be cared for. And I think a lot of guardians don't necessarily expect that might become part of their responsibility.
Right.
So, Karla, going back to your question, what can someone who is in advanced age right now can do? If they still have their capacity, then the best thing they can do is to see a estate planner or elder law lawyer, because Peggy is absolutely right. You want to be the person selecting who steps in when you become incapacitated and not the court. And that's the whole beautiful thing about advanced planning. And folks may say, I don't want to spend a couple $1,000s or whatever it may be to do some estate planning. Well, I can tell you and I can assure you that if you don't do that, you're going to be spending a whole lot more in litigation later on if you have a family that may not get along. And Peggy and I have seen that happen time and time again, where folks just wait too long and become incapacitated, and then either are the subject of a contested guardianship or after their death, a contested estate.
And costs of litigation are not always financial. I mean, they can be emotional, they can be spiritual, they can certainly suck up your time, your energy,
Right.
your ability to spend time with your own family, have your own life. For some people, it's just a dark cloud that lives over their head, can destroy family relationships. I think Alex and I would both agree that our overall goal would be to promote family harmony. And by doing prior proper planning,
Right.
we can do that.
Great. Well, thank you guys. Before we close out, I do have one more question. If our listeners would like to follow up with you about the topics we discussed today, how could they reach you?
I can be reached at Peggy at Hoytbryan, HOYTBRYAN.com, or through my website at hoytbryan.com.
And I can be reached at adouglas at SLLAW.com, or our website at Shuffield Lowman, SHUFFIELD, Lowman, LOWMAN.com.
Well, this has been another edition of the Florida Bar Podcast, brought to you by the Practice Resource Institute on Legal Talk Network. I want to thank our guests for joining us today. It's been very informative. If you've liked what you heard today, please find and rate us in Apple Podcasts. I'm Karla Eckhardt. Until next time, thank you for listening.
Thanks for listening to the Florida Bar Podcast, brought to you by the Florida Bar's Practice Resource Institute and produced by the broadcast professionals at Legal Talk Network. If you'd like more information about today's show, please visit LegalTalkNetwork.com, subscribe via iTunes and RSS. Find the Florida Bar Practice Resource Institute, and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.